such offices, provisions of the law breached, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced. Accordingly, the court is unable to find in his favor on this issue. On issue number 8, the court was unable to find in favor of the petitioner, the same on even the assisted voters. Because with the assisted voters, what I have done is that I have said I take seriously the caution by the superior courts concerning unpleaded evidence gathered through scrutiny. The outright determination, the overall determination, for all the foregoing reasons, the court finds that the petition was not proved to the required standard, and it is hereby dismissed with costs. The costs are as follows. The parties made submissions on costs, generally to the effect that costs follow the event. The first to third respondents' counsel went into some fair detail in indicating the depth of the case, the number of attendances, preparatory time, complexity, and so on. The first to the third respondents and the fourth respondents both indicated that costs should be at Kenya shillings 5 million. The petitioner only submitted during highlighting. So having considered the nature of the case and the input of the parties and noting the fourth respondent did not testify to or avail witnesses, I hereby cap party and party costs at Kenya shillings 4 million. The first to third respondents shall be entitled to 70% thereof, and the fourth respondent to 30% thereof. I have prepared a report of the court on electoral malpractices under Section 87 of the Elections Act, which is as follows. The court finds that the following malpractices of a criminal nature may have been committed. And directs that the same be transmitted to the DPP. A. Admitted alteration of register without authority, contrary to Section 6(1) of the Election Offences Act. B. Double assistance of voters, that is allowing 6 persons to assist more than one voter, each contrary to Regulation 72(5)(c) of the regulations. C. Failure to record in the polling station register against the name of the voter the fact that the voter was assisted, contrary to Regulation 72(6). I will make recommendations separately. I will not, because there's no point of putting the recommendations in the judgment, but I'll make recommendations separately, particularly for IEBC's notice, subsequent to this judgment, because I think it is important. Certificate of court as to validity of the election under Section 86 of the Elections Act. Having concluded the hearing of the election petition, I certify that the petition was dismissed and the fourth respondent remains the duly elected member of parliament for Mbeere North constituency. This information is to be transmitted to the Speaker of the National Assembly. Orders accordingly.
Yeah, my Lord, we are most obliged by the decision of the court. We have sat and listened to it. We appreciate where the court is coming from, but we, however, would wish to make an appeal in regard to some of the issues the court has dealt with, and therefore, my Lord, we are making an application for expeditious provision of typed proceedings, the judgment of the court, and the decree accruing therefrom. Your Lordship, the reason for the appeal is, my Lord, that this might be the only time the certain issues will be clarified by the Court of Appeal, most importantly, the question of the alteration of the voters' register. And, my Lord, since I am not making an appeal before you, would wish to make the Court of Appeal pronounce itself. Number 2, Your Lordship, on the question of the scrutiny that was dealt with by the Deputy Registrar. My Lord, we have listened to you and the judgment, and we note that the judgment itself does not caption the entire report as reported by the Deputy Registrar, and most importantly, in respect to ballot box number 35 and the 212 votes that were cast in foil paper. We have not heard you pronounce yourself on that, Your Lordship. Would we therefore wish to make an appeal? And then, my Lord, I don't know how that will square out, because it has not been captioned in your judgment. Because, my Lord, when you ordered,
it should be easy enough, because the proceedings of the registrar will be part of the proceedings of the
yes,
court.
my Lord.
So you just annex them and say that the lower court failed to deal with an issue.
My Lord, we will be obliged.
Yeah.
We are otherwise happy that the court has made its decision. We'll try our luck in the Court of Appeal. We are most obliged.
Fortunately, the judgment is typed already.
Yes, my Lord.
The proceedings are typed, so it should be fairly easy to get the record fairly quickly.
We will get it, my Lord.
Okay. Yes, Waduta.
Yeah, my Lord, Gerard Waduta, and I thank you for that judgment. My Lord, I just have one request, and as we review the judgment, so that then we can see what we make of it in terms of what is the next step. We would just like to make an application for stay of execution on the issue of costs, because we know we have money in court.
Yeah. Go ahead.
Yeah. So that, my Lord, the issue of costs may be given about 30 days for us to review the judgment before the money is released, if such an order is sought. So that then we can make the appropriate application, if any, upon taking instructions.
Okay.
So that, my Lord, if, as Mr. Ndegwa mentioned, if there is any need for review or clarification from the court, then we can have that period to consider all those options.
All right.
That's all.
Thank you.
Yeah, I've been informed that I seek 45 days.
45 days.
45 days.
I think you have 30 days, actually. I think, well, yeah, he's asking for 45.
Yes, I hear him, my Lord.
Yes.